Good evening. This is a special meeting of the Walpole Conservation Commission to review an open meeting law complaint review. Since this is the first time in my over 40 years of dealing with a complaint, we will proceed and get some, hopefully resolve the issues at hand. I would think that we probably start with the site visit, which was June 19th, 2025.
Maybe also Chairman, if someone wants to read the complaint.
Do we need to read that into the record?
Probably. I would just think it would be helpful.
Okay, why don't we do that? Okay, this is a complaint filed by Elizabeth Barrows of 189 Union Street, East Walpole, Mass. And was done on June, let's see, I don't know when it was filed. Let's see the file date.
Well, we received it on July 21st.
July, okay, received by Conservation Commission on July 21. And this is a description of the alleged violation. Okay, Conservation Commission held a site walk meeting June 19th, 2025 at 5 p.m. Location was Union Square Village, Brook Lane, East Walpole, Mass. This was a continuation of a hearing. Notice of meeting was posted on the town website. Purpose was to collect information regarding a request to amend an order of conditions issued to Wall Street Development. There was a quorum of members present participating and discussing a matter within their jurisdiction. The chairman, Jack Wiley, was managing the meeting. Despite our objections and best efforts to communicate the impending violation of open meeting law, the chairman did not permit residents in attendance to walk the site with the commission and applicant as they discussed the proposed amendments. I observed members deliberating with each other and the applicant. However, we were not allowed to hear or see the presented information. Upon their return to the spot that we were permitted to stand, we were informed that the question would be taken at the next meeting. While I cannot speak to any other person's thoughts or opinions at the meeting, it seemed like some members of the body were not comfortable with the decision of the chair. We were on private property of the applicant. It is his discretion not to permit myself and others on the property. However, a quorum of the body was present and deliberating the matter. I believe that the chair understood the nuances of the open meeting law and chose to ignore it because the conservation agent was not present. Before getting into that, I would suggest that we verify, yes, the conservation agent was not present at the site visit. The site visit was June 19th, 2025 at 5 p.m. as stated, and was selected at the prior Conservation Commission meeting as a time to do the site visit. The purpose of the site visit was to gather information regarding a trail that the applicant wanted to include in the development. What's this development called? It's on here someplace. The site, what's our title of this?
Union Village.
Union Village. It was, a trail is
Union
proposed
Square Village.
by the applicant to include with the Union Square Village application. So again, the purpose of was to just review the site. The applicant had staked out an approximate location of the trail that was being proposed, and the applicant also staked out property line of abutters near the, that were near the proposed trail. The, at the beginning of the site visit, the abutters, there were two or more abutters at that, there at the time, including Elizabeth Barrows. Asked if they could join the site visit. The applicant emphatically stated no, they would be considered trespassing, and they were not allowed to be on the site visit. We did the site visit, went along the trail. Most of the questions that came up, there were two issues. One was where we started the trail was a predominant ground cover of poison ivy. And we proceeded on along the trail. And then basically the questions were, where are we on the trail and how is this relative to the property line? The trail was staked out, the property line was staked out, and these points were pointed out where we are, where we were on the trail and where the property line was. One of the other dominant, wasn't ground cover at this point, I would call it shrubbery, was,
Honeysuckle.
it was Japanese honeysuckle, which is a shrub. Would you
Yep.
consider that a shrub?
Yep.
Yes. And that in another area was the dominant shrub layer. There was, and not much else besides that I can recall was and that was asked and pointed out that this was the other invasive, or the invasive species that the applicant wanted to remove from the area. He had done some trimming so we could get through the trail area. And then we came to the conclusion of the, along the trail of the site visit. One of the abutters did ask, and it may have been Mrs. Barrows, I forget who it was exactly, that said that this was, it was an open meeting as published that for the site visit, and that they should have been allowed to participate, and I just responded with no, they weren't allowed, with the statement that had been made before that the app did not want them on the site and would consider them to be trespassing if they did. At the conclusion of the site visit, because of the poison ivy, a substantial amount of poison ivy at the beginning of the fight, I offered everyone on the commission that was present to rub down with rubbing alcohol and handed out the rubbing alcohol and paper towels to accomplish that. And as far as I know, it succeeded because not anybody got poison ivy. And beyond that, I did not interact with the abutters, and I didn't really interact much with the commission members afterwards, other than here's some rubbing alcohol and paper towel, and that was about it. There was a subcontractor was there, and just was some general conversation. As I recall, it was more about the weather and how hot it was. That's all I recall from after the site visit. There was no deliberation. between members that I'm aware of. There was no deliberation with me or anyone else or the applicant. So there was no discussion of proposed amendments. And it had nothing to do with the fact that the agent wasn't there, that was the reason for not allowing the abutters on site, was that the applicant had stated emphatically that they were not allowed to come on the property. Leave it open to further discussion.
Yeah, I will add something. I had to go and look it up. I've been on the commission for 19 years, since 26.
Thank you.
Yep. I cannot remember a time when a developer has not allowed abutters, even if there's been contentious meetings about it, because going on a site visit together tends to kind of smooth things out. You go, oh, so that's where the drainage basin is. Oh, I see the slope is not going into my basement. So it usually is something, even if everyone's not in the friendliest of terms, it's worth doing and developers see it. So I think the deliberation, because I know I was part of it, of like, what do we do, was me just going, I've never seen this before. I just have not seen it in 19 years, that someone wouldn't allow the abutters to go on a sidewalk. Maybe you guys have seen it, but.
Well,
yeah,
I'll
yeah.
comment on
Oh,
that.
oh, okay, have you, Jack? Okay.
Yes.
Oh, all
Over
right,
the years.
all right.
We have had on-site visits where non-commission members have asked to go on the site visit.
Yeah,
We have had some where the applicant said, okay, you can come. We've also had some that said, you can come, but you have to sign a waiver of, a waiver, of, I'm assuming, of liability. We're not concerned with that, but they had to sign a waiver. And some where they said, no, you're not allowed. So
Okay.
over the years, there have been all three situations. Mostly, I agree that mostly they're allowed, but
Yeah.
I don't know what the reason was for the applicant to say, no, you are not allowed on this particular site visit on June 19th. Other than he did make reference to a situation that had occurred several days prior, which he did not elaborate. I did not ask what they were. He just said there'd been an issue a few days before that apparently had involved the abutters who were there at the time, who were at the June 19th site visit.
okay.
So
But
I don't know what that was.
on the topic of whether there were decisions or deliberations or anything offered, around amendments, I'm gonna say no, and because I explicitly remember Lou saying to you, but I was next to you when we were in the woods, I would like to toss out the possibility of having a well put in to handle the lawn situation, and either you or I, because I know we're not supposed to do that, one of us, I think I said, we're not allowed to discuss anything like that when we're on a site visit. So even though I was surprised the abutters weren't allowed, and I realized that Lou was probably within legal rights to not allow it, I knew we were not supposed to be deliberating. In fact, we're not even supposed to have a substantive discussion between us. It's sometimes difficult, we have to kind of hold ourselves back, make a little comment, but you're not supposed to have a deliberation, and so we squelched that one. We said, we're not talking about a well. Remember that, Jack? Or was I the only one that remembers it?
You may have mentioned that a well, it was beyond our jurisdiction, it's not something we could,
But it was more that we were not supposed to be discussing it.
right, but I think you said that we couldn't really, that's not a well, but that regardless, we didn't,
Yeah, it's been vague in my mind about that, but it would have been, as you said, not
Yeah.
something that we should be discussing.
Right, and then when I went to look this up, because once we saw the complaint, I was like, whoa, Is it really that the abutters can be forbidden to go on the property? I found out, yes, it is. It's rare. It's disturbing, because I think actually allowing people to see what the situation is can smooth things out. I'll also notice, and I would say this to Lou if he were here, if he's watching on television, hello Lou, that he has unusual levels of disagreement with the butters, because it's not just Brook Lane, it's Pinnacle, it's Doopy, it's, I think, Darwin Lane. I mean, I don't know how those site visits all go, but there's a strange common denominator here, and it's not the usual thing. I just haven't seen a lot of it, and you haven't either, even in your 40 years, right?
So, can I just
Go
add?
ahead.
Oh, sure, sure.
I don't want to jump in front of either of you if you have anything additional to say, but
No, I would agree with Jack. The purpose of the visit and what we did on the visit was look at where the trail would be in relation, and in relation to the boundaries where they were, and what the type of invasives we encountered, and other types of, there were dead trees and logs, and he talked about what possibilities that, that what to do with them, are possible, but there was no decisions made. We said, whatever, but we just walked the site and then came back out. That was kind of it.
Yeah, honestly, most of the conversation that we were having was about the poison ivy.
Yeah. And some people hadn't dressed for it.
That is correct, but I did not get poison ivy.
I didn't get any either.
So a couple of the points in the complaint. One, that it said the Conservation Commission held site walk location, and it said this was a continuation of a hearing. This was not a hearing. That the whole purpose was this was a meeting. There's a very difference between a hearing and a meeting. A hearing is advertised in the newspaper. We read the ad, we open the hearing. It's all done in the public. A meeting is, like, this is a meeting. This is not a hearing per se, that this was not advertised in the newspaper. It was a meeting. It was the meeting of the Conservation Commission. It was a quorum, so we had to post it within 48 hours. There's different requirements for a hearing. It was not a continuation of the hearing. Otherwise, you
Right.
could have deliberated and you could have rendered decisions, but it had to be, everyone had to be present. At site walks, that usually doesn't, it can't happen. So it's just was a meeting. So there's no decision-making, there's no deliberation, regardless of if the applicant had allowed abutters to come on site. The commission should still not be deliberating or making any decisions, because it's not a hearing. There's no recording, there's no minute taking. It's just, the purpose of a site visit is to go review, take in the information that you can't take from plans or somewhere else, and then to bring that back to the public hearing and have a conversation. And I think that's what I wrote in my report beforehand. So I just want to make that clear. There is differences between hearings and meetings. This is a meeting, a hearing is advertised.
Which I think we did use that information gathered at the site visit at the next meeting we had, which was a public hearing, whatever the date that would have
Okay,
been.
so the second line in this complaint, this was a continuation of a hearing. I want to back up Landis on that. This is not a continuation of a hearing. This is simply a site visit. And to expect that members of the commission would go on a site visit and be mute and say nothing to each other or anyone is not a reasonable interpretation of the law. So I think that right there in her second line is the gist of the problem here. And I've never heard of an abutter requesting the commission elect another chair. That's not an abutter's role. So I was not there. I've seen the site many times. And there's more than just a couple of items that are invasive species. There's invasive species that has been all over the place. There's also a virus, a disease of ash trees is very, and whether or not that disease of ash trees affects the soil, I don't know. And it would take a very elaborate study for somebody to find that out. I know that the disease is spread by a bug, an insect, and just like elm trees have almost become extinct in the Northeast, and the chestnuts. You know, this nation, years ago in the 1700s and 1800s, the dominant timber species was chestnut. That all succumbed to a virus spread by insects. So any effort to remove invasives and diseased material in the process of construction there is important. Because if you don't remove the invasives, they're just gonna take over, no matter what you do. So I think the important line here in that whole document is she didn't realize that this was not a continuation of a hearing. And so I have to emphasize what Landis just said.
Yeah.
Great, thank you. So I think you guys went over the deliberation part pretty thoroughly, that you conveyed that you didn't deliberate on the site, and that's important. And just to clarify, I think hearing and meeting have been used both in this complaint, so maybe it wasn't understood, because it was a continuation of hearing, but also says notice of meeting. So that's something that I just clarified, and Al also clarified. And the other thing, which Jack had already mentioned, was that the complaint does say it's the owner who is the person that says you can't come on to my property, or you can come on your property. Owner's rights are very strong in Massachusetts, so owner has every right to refuse access. And as Jack stated, and you guys heard the same thing, it was Lou Petrosi was present at the site, and he was the one that said, you cannot access the property, and it was Jack that was just repeating that. So if that's the case, we would also put that in the response to the Attorney General. And then the third thing, so I think as far as site visits, I've been on site visits with the commission a lot. I've also been on sites with DEP, and I think sometimes what DEP does, if there's this issue, and there was an issue at Pinnacle Point, and it was the presiding judge that came and said, and he basically said, everyone stays here, I go.
Right.
Because his position was to go and collect information. So the commission might consider that. I think you might consider that. If this situation happens again, that you consider, if you're if applicant owner, if you're saying that no one can come on the site, and there's a butters here, and we find that it's important for butters to come, then we won't come on the site. So I'm just saying, you could consider that, not moving forward. Or you could consider going on the site and trying not to say anything. I know it's really hard if you're walking around in poison ivy. Why I'm saying this, I'm just suggesting, is there any way that we could do better so that it's clear what's going on with the situation, so you don't get into this again.
I guess the start of this is at a public hearing where there are abutters present and people that are complaining about the project, which is their right to complain. I think it should be made clear to them that a site visit purpose is to gain information, it's not for public discussion, it's not the same as a public hearing, and to make sure that everybody understands that right from day one.
Right, and I think I put that in my report, and I understood you guys did go over that, because I also wasn't at the meeting for the site visit, because I was sick.
Yeah.
So I had put that in my report, because I had meant to go over it, but my understanding, you guys did go over how you were gonna conduct the site visit.
Yeah, but we might have asked, but it wouldn't have occurred to me because it's just so rare in my mind. Lou, are you going to allow abutters? And then right here in this very meeting, he would have said no, and then,
Yeah. We could establish that ahead of time.
which we don't usually
There was-
do.
There was no request, as I recall from the meeting prior to set up the site visit, there was no request from abutters to join the site visit.
But they don't have to
Oh,
request.
no, they don't
right?
have
They
to,
don't have to request.
but
it.
it-
So
there was
you
no
could ask
request to come up.
The applicant ahead of time. We may have a butters, it is a posted meeting.
I personally feel that that is the landowner, and in this case, the applicant's decision to make.
Oh,
And the
here it
purpose of the site visit is for the commission.
But making it on the spot in the field versus like it could actually be brought up here in the meeting when we're
Could be and
setting the
discussed,
date.
but I think that the landowners have certain rights. We have certain rights. Once an application is made by the applicant, whether it's the owner or an applicant, we then have the right to access the property. It does not include access to the property by anyone other than the commission. So that's my personal feeling that we need to
And
recognize that the landowner has some rights. And also the commission does.
Right, but I think what I was saying is if you knew ahead of time, then the commission could make a decision if, then we're not intending to make a site visit if you're not gonna allow abutters to come on the property, that
But-
you would have a discussion about.
That would be subject to discussion, yes.
Speaking for myself, I think seeing it on paper is one thing, but the site visit was beneficial to me, for me, to see it physically.
Yeah.
So to not have gone would have been detrimental, I think, for me anyway, in forming an opinion or forming a decision. You know, I needed that information to see it. It helped me. So to not go would have been not an op for me anyway. I wouldn't have.
Thought it was I also agree with that. I thought it was a very beneficial site visit.
Yeah, to see the boundary, to see the conditions, to see what he had in
We had-
mind.
We'd had many site visits over the last several years on that site, but this was specific to this issue of the trail, and I thought it was very beneficial.
So,
Right, yeah, on this particular instance. And sometimes there's applications where just individual commissioners go and take a look so that there isn't a quorum issue and a posting issue and all that, so. I was just bringing up that maybe having some discussion included in the site visit,
Yeah.
just
Especially,
that-
yeah,
everyone is clearer maybe of the site visit.
yeah.
I think we absolutely attempt to do that, so.
Because when site visits are announced in this room, you see abutters writing the date down. So our next question should be, oh, by the way, our abutters are allowed. To get it
Probably could
cleared
ask-
right
Probably
in,
could ask,
Yeah, right.
Or even just saying that the property owner has a right to
Yeah.
refuse entry
Mm,
and
Okay.
even leave it at that.
Any other comments that we want to make at this point? Okay, open it up. Anybody in the audience like to make any comments? Okay, hearing none.
Would anyone like to ask me any questions to get clarification on?
I just asked, is there anyone in the audience who wants to comment?
I apologize.
You might I need a
If you
microphone, yeah.
Use the microphone and also please sign in.
Sure. My name's Elizabeth Barrows. I am the person who filed the complaint that's being discussed tonight. I just came tonight on this, and I didn't know if I wanted to be present in case any of the commission members had questions for me about why I submitted my complaint.
Why did you?
You're asking if any of the commission members have
If there's
a
anything I can.
question for you.
Correct.
Okay, I just want to understand your comment.
They have none?
Landis, you have any question?
I wasn't there, so it's a little hard for me to ask a question,
Okay.
but, so I'll let.
Jessica?
Not at this time, no.
Emilio? Al?
Well, I will make a comment. I've been in a position before that, where I would have liked to have been on a site visit and wasn't allowed. But I understand her interest. But I think that her interpretation of the law and what the reality of the law is are probably two different things. And I sympathize with her in that context, but there is a very distinct difference between a continuation of a hearing and a site visit. And that's all I
Okay.
had at this time.
Thank you. Betsy?
Liz, I think you would like us to ask why, so please tell us why.
No, I guess I used the wrong terms. I should not have said a continuation of the hearing, although it was to gather information for that hearing. But I should have stuck with open meeting and quorum, because I do believe that those two facts are correct and true statements. So I think that it would apply to the open meeting law, excuse me. You weren't here, so this project, as you know, you guys have been on it, the owner of the land has proposed many projects on this particular parcel or parcels. And I don't recall when it was, but I want to say it was 2017 at a different notice, so to speak, where the commission walked the site. And I remember being in the hearing the commission was discussing walking the site with the applicant for the first time. And it was my recollection that Landis brought it up with the applicant at that time in front of the board and said that, well, Lou, we can't do, you have to let them, otherwise we'll have a quorum and we can't do that. And at that point in time, he agreed to let us come. So for me, this whole issue was already discussed at this particular regarding this applicant and this particular piece of land, and then I don't know if we just don't remember that this was already an issue that was open, so we can't say that we don't recall it ever happening, because it happened, and that's why he granted permission at that point in time. Am I not remembering this correctly?
I don't recall whether in a site visit in 2017, give or take, what specific questions or comments were made, but if you were allowed on that site visit that was specific to that site visit. I don't see the connection between the site visit of June 19th and any prior site visits.
It's,
I would, if I could address, can I address? I would say my experience with the commission over these past 23 years is they prefer for everyone to be at the site, be able to walk the site visit, and that they try to persuade the applicant to allow for that. But the law clearly states if they say no, they say no. So I guess that's my, I don't remember that particular hearing per se, but I do remember the commission kind of advocating for butters and, and trying to get the applicant to allow everybody, but the law that the property owner can say no is still there. So, but yeah,
and I'm not
I know,
I'm not contesting that.
yeah.
My issue is,
You thought a precedence was set and you thought it would be applied.
no, just that, I guess I didn't know. I don't think that, an excuse of not knowing should be applicable, even though it's rare. And then the other thing is, while I don't believe any of the members were making decisions, part of it was pointing out that there was nothing staked, and the applicant was pointing out which trees and which things, and there was dialogue about that, and how could you not do that and collect the information that the board wanted to know?
It's data gathering, that's why we're there.
Exactly.
It's not it was the data gathering.
Let me correct, you said that it was not staked?
No.
Yes, no, you're wrong. The applicant had staked out the property line abutting the area we were looking at, and had staked out the trail, roughly staked out the trail where we were proceeding along. And this was, as I said earlier, one of the many questions we got, okay, where are we on the trail and where is the property line?
What was used to stake the trail? Because I had,
Well, you
Gone
weren't
on
on the
and I
site
did see
visit,
it.
so I don't know how you would know whether there were stakes or not.
because I abut the property, and that's why I wanted to know what was used to make the stakes, because I
The
visually didn't
stakes,
see it.
the trail was roughly staked out, which we followed through.
What item was used?
Pardon?
Was it a flag, or, and
It
how
was a stake in the ground with a
consistent was it?
flag on it.
And they
A
were
plastic flag, whatever color.
every 4 feet, or?
No, it was 50 feet, 100 feet, maybe.
Yeah, it was pretty vague.
It was, yeah, there weren't,
He hadn't done a brilliant job of it.
well, but it was roughly, we start at this point, and that's where the poison ivy was, at the beginning of the trail, and a huge patch of poison ivy. And we followed that through and went from stake to stake as, and had there been some trimming of shrubbery along that proximate path. But there were stakes. And there were property line stakes, and that was a common question, where are we relative to the property line? And I believe is your property line. So that we knew the trail was away from, it wasn't on your property line, there was some distance between the trail and your, and the property line.
I never had concern that his trail would be on my property.
But there were stakes, I did want to correct that there were stakes, and we followed those around,
Okay.
okay? Anything else that you'd like to say?
No.
Okay.
Thank you.
I would, based on what you've heard this evening, I have a comment for you, if you want to
Sure.
listen.
Happy to listen.
Do you still think that this is a valid complaint?
I do.
Okay, that's all I want. Okay,
Part of it, I think that there are portions of it that I still,
basically, your complaint was that there was a violation of the open meeting law. I thought we had made that clear with the explanation tonight, that it was not a violation of the open meeting law. Now, you still believe that there was a violation of the open meeting law?
I think that there was dialogue that was substantive.
I
Dialogue.
think the part of what we're doing tonight is with the discussion of the complaints, is the commission will then put together their response to the Attorney General. The Attorney General is gonna decide if it's open meeting, if it's a violation of open meeting law,
I
so.
just want to know
Yeah.
whether the complainant still thought it was a violation of the open meeting law.
No, I know, I understand, I'm just clarifying.
Because substantive dialogue was going on, so immediate, substantive dialogue. Because we try really hard not to have substantive dialogue.
We asked questions about where the line was.
Yeah,
and
where's
trail
the
was. Is that-
line, where are we?
Right.
And by the way, it was not easy going, so we weren't chatting away with each other. You fell down, we had to all haul you up. It was really kind of a dangerous place to walk.
I was hoping you wouldn't bring that up.
I think I said, that's honeysuckle. It's like, we weren't,
this is-
and then we said, no, we're not discussing a well, in so many words. I mean,
You weren't
because often,
specifically locating where the path.
right,
Okay,
right.
I
But he
understand.
wanted to bring up an additional thing, because actually, sometimes this happens on walks. Developers want to get chatty and talk about some other things they could be doing. That we know not to do. Yep.
I do not recall any discussion of deliberation, what would be called deliberation of what would then ensue as with the
Right.
order conditions that we then wrote at our following meeting. That was an open meeting in which we did that.
And part of that is to go into fields and actually flag out where the path is gonna go with where the invasive species are. And not taking down other vegetation. So that's part of the order.
Do we need to vote on anything?
What?
Do we need to vote on
Tonight?
anything, or are we just reporting what was said?
I don't think you have to vote on, I think
Okay.
just have a consensus.
Just
Thank you
wanted-
for
yeah.
coming, Liz.
Thank you.
Thank you.
Thank you.
I think what we just need to do is, Sarah's been taking notes, and I can write up something based on the notes and then send it out, make sure it's what you all agree, to
Do we have to
respond.
vote on the response?
I think so, I don't think so.
I'm not
If you
sure.
want to, if you want to get a consensus from the board.
I don't know
You
what
don't
it
have to, I
is.
think we really need to turn this over pretty quickly,
Yeah,
because there's 14 days for the public body to meet,
okay.
and then, yeah, the after review, but within the 14 days, the public body must respond to the complaint, so that's by the 8th.
We
So
have-
basically, you're not gonna meet.
We have 14 days from today.
No, 14 days from the receipt of the complaint, to hold this meeting that we're having now, put together a response and send it to the
Okay.
Attorney General by I believe it's the 8th.
Okay. It doesn't say anything about voting on it. Okay.
You could vote to delegate the responsibility to your staff.
It's in here, but we could do that vote for Landis to, let me make a motion to have Landis respond to the complaint.
So moved.
Second.
All in favor?
Aye.
Aye, okay. Anything else we need to talk about this?
I don't think so.
Okay,
Unless nobody else has anything else to put into it.
okay. So we'll make a motion to close the hearing then?
Second,
Meeting.
all in favor? Aye.
Right.